Here in Perry County stands an ancient oak with 22 notches carved deep into its trunk.
Mountain Phantom, the Combs brothers, hunted 22 Marshals who hanged their grandfather in 1887. Chapter 1. What the Ground Remembers. The grave was on the east slope of Burnt Ridge, under a white oak that had been old when the first Combs settled that hollow, and Dillard Combs had been in it for 31 years before his grandsons were old enough to understand why. Eli Combs learned it first, because Eli was the elder by 4 years, and their grandmother Nora had decided, in the particular way of mountain women who understand that certain knowledge has a season, that 14 was the right age for a boy to be told what had been done and who had done it. She told him on a January evening in 1918, with the fire banked low and the wind off the ridge working at the window frames, sitting across the kitchen table from him, with her hands folded and her face wearing the expression he associated with the most serious things she ever said, which were few and considered, and did not arrive until she was certain the listener was ready to receive them. She told it without embellishment, and without the softening that adults sometimes apply to hard truths when delivering them to the young. She said, "Your grandfather Dillard was hanged by federal marshals in August of 1887. He was 43 years old. He had not committed the crime for which he was charged, which was the killing of a revenue agent named Pratt in the summer of that year. Because on the day Pratt was killed, Dillard was on this property in this house with me and your father and your uncle Chester, and I know this as certainly as I know anything I have ever known. The men who killed Pratt were affiliated with the Keller family from over the Sawback Ridge, who had a long dispute with the Pratt family that had nothing to do with us. And they needed a name to put on the killing that was not their own name, and they chose your grandfather's name. And they had enough connection to enough people in the federal apparatus in this district to make the choice hold." Eli sat across from her and listened. She said, 22 marshals and deputies were involved in the proceeding from arrest to execution. Some of them were instruments of others, men following orders they did not originate and may not have questioned. Some of them were active participants in the arrangement, men who knew what they were doing and did it for money or for the benefit of a relationship they valued more than the life of a man they had been told was guilty. I do not know the exact distribution of guilt among the 22. I know their names. I have known their names for 31 years. She reached into the pocket of her apron and placed a folded piece of paper on the table between them. She said, "I am giving you this because you are the oldest, and because I have watched you for 14 years, and I know what you are. I'm not telling you what to do with it. A woman who has lived my life does not tell a young man what to do with something like this, because I know that what he does with it will be his own, and not mine. What I'm telling you is that it exists, and it is accurate, and it represents 31 years of my knowing, and it deserves to be in your hands now, because mine are getting old." Eli unfolded the paper. 22 names, written in Nora's careful copper plate with notations beside each one. A date, a role in the proceeding, a location as of the last information she had been able to obtain, in some cases an additional note that he would need more time to understand. The list was dated in her hand at the top, compiled 1887 through 1917. 30 years of maintenance. 30 years of a woman sitting with this list and adding what she learned and noting what had changed. He looked up at her. She said, "Your brother gets told when he is 14. That is 4 years from now. I leave it to you whether to tell him before then or wait for his season." She pushed back her chair and went to the stove to tend the fire, and the conversation was over in the way of mountain conversations that are complete, that do not need more words, that have said what they came to say and are now simply part of the permanent record of things spoken and received. Eli folded the paper and put it in his shirt pocket against his chest, where it stayed for 3 days before he found a better place for it. He did not tell his brother Harmon yet. He spent those first months doing what he always did when he received significant information. which was to sit with it and turn it and examine it from different angles before deciding what it meant and what it required. He was a methodical boy who had grown into a methodical young man. And the methodicalness was not a personality affectation, but a genuine orientation toward the world, a preference for understanding a thing accurately before acting on it. Their grandmother had seen this in him correctly. He was not impulsive. He was not given to gesture or dramatics or the kind of action that produces relief but not result. He went to the grave on the east slope of Burnt Ridge several times that winter. He had been going there since he was small, had grown up with the grave as a feature of the landscape, had understood it as a place of family significance without understanding the full dimensions of that significance. Now he went and stood beside the white oak and thought about a man he had never met, and about 31 years and about 22 names on a piece of paper. Dillard Combs. He had been 43, which was only 25 years older than Eli was now, which made him feel suddenly proximate in a way he hadn't before. 43 and hung for someone else's crime because the Keller family had needed a name and the federal apparatus had been persuadable. Nora had been 36. His father Leland had been a boy, Chester younger. The family had absorbed it and kept going, the way mountain families absorb catastrophe. By continuing, by working the land and raising the children and not speaking of certain things until speaking was the right action, which sometimes took a generation to determine. Nora had waited. 31 years of knowing and waiting for the right hands. He was the right hands. He accepted this without grandiosity, because grandiosity was not in him. He accepted it the way you accept an inheritance, with the awareness that it comes with obligations, and that the obligations are yours now whether you wanted them or not. He turned 18 in March of 1918 and enlisted in the army in April, as most young men in the mountains were doing that spring, because the war in Europe had arrived at a scale that demanded it, and because Eli Combs was not a man who stepped back from things that demanded. He served 14 months in France and saw things that he would never describe in full to anyone, though what those things did to him was not precisely what war does to men who are broken by it. He came back intact, or as intact as a man can come back from that, but rather a kind of calibration, a revised sense of the scale on which human cruelty can operate and the durability required to work against it. He came home in the fall of 1919 to the home place on Burnt Ridge, and his grandmother was older and his father was older, and Harmon had turned 14 while Eli was gone, and Nora had told him. Eli came home to a brother who already knew. They sat on the porch the first evening and looked out over the hollow and the creek below, and the opposite ridge going dark in the October dusk, and after a while Harmon said, without preamble, because they had always been able to do that, to pick up a conversation that had not yet started as though it were already underway. I looked up what I could find in the county records, the trial record from 1887, the arresting documents. 3 of the names on grandmother's list matched the official record directly. The others would require more digging. Eli said, "How long have you been at this?" Harmon said, "Since she told me, 8 months." Eli said, "Show me what you have." What Harmon had was already substantial, because Harmon was a different instrument than Eli. Where Eli was methodical and patient, Harmon was fast and lateral, with a mind that moved sideways through problems and found connections that direct approaches missed. He had spent 8 months in the courthouse records room and the state archives and the newspaper files at the county library, and he had built a secondary document on the 22 names that cross-referenced their grandmother's information with official records and press accounts. And what this document showed was a picture of the 1887 proceeding that was considerably more detailed and considerably darker than even Nora's account had suggested. The killing of Revenue Agent Pratt in the summer of 1887 had been, Harmon had established, not an isolated incident, but the terminal event in a 3-year conflict between the Pratt family's revenue enforcement operation and the Keller family's whiskey production in Sawback County. The Kellers were large and politically connected, and they had, over those 3 years, used those connections to ensure that the revenue enforcement was applied selectively, targeted at families like the Combs, who competed with the Kellers' own operations, while the Kellers themselves operated with relative impunity. When Pratt, who was, by the account of his own supervisor, an honest man and the most aggressive pursuer of the Keller operation in the district, was finally killed, it was by a Keller man named Tom Stacy, who had been part of the family's enforcement apparatus for a decade, and everyone in the district who knew anything knew it. What they did not know, or what they were persuaded to unknow, was how Dillard Combs's name came to be attached to the killing instead. Harmon had found the thread of it in a series of letters between a federal district attorney and a man named Holbrook, who sat on the county board and whose brother-in-law was Keller's business partner. The letters were in the state archive in a collection of administrative correspondence that had been misfiled under a different case number, which meant they had survived when they should not have, which was the kind of accident that the truth occasionally produces. The letters were not quite explicit. They were the letters of men who understood that what they were arranging was not arrangeable in direct language, who had developed, as men in their position always develop, a set of circumlocutions that were deniable on their surface and legible to anyone who read them with the right prior knowledge. But Harmon had read them with the right prior knowledge, which was 31 years of his grandmother's accumulated understanding, and what they said translated was, "The Combs name will hold, the jury will be managed. The Marshal's office will provide the necessary personnel, and the matter will close." The matter had closed. Dillard Combs had hanged on a Tuesday morning in August 1887 and been buried on the east slope of Burnt Ridge under the white oak, and the matter had closed. Eli read Harmon's document through twice. He said, "Who's still alive?" Harmon said, "I've been working on that. Of the 22, I make it that 11 are dead by now, natural causes. 2 I can't determine. 9 are definitely still living, ages ranging from 60 to 83, Eli said, "and the Kellers." Harmon said, "The main Keller family is largely gone from the county. 3 died in the 90s, 2 moved west. There's a grandson, Purvis Keller, still in Sawback County. He's 35 and he manages what's left of the family timber operation. He had no personal part in 1887, he wasn't born, but he's the inheritor of the business that the killing of Dillard Combs protected." Eli was quiet for a while. He said, "We need to be very clear about what we're doing and what we're not doing." Harmon said, "I know." Eli said, "Say it. I want to hear you say it." Harmon said, "We are not going to hurt anyone. We are going to find out what happened precisely and completely, and we are going to put it in front of the people and institutions that have the authority and the standing to do something with it. We are going to be the record. We are not going to be the hand." Eli said, "Yes." They sat on the porch for a while longer as the hollow went dark below them. Then Harmon said, "I found something else in the archive. There's a federal statute. It's been on the books since 1871, that provides a civil remedy for the wrongful execution of a person by federal officers acting outside their authority or in furtherance of a conspiracy. It's never been successfully used, but it exists." Eli looked at him. Harmon said, "I'm just telling you it exists." Eli said, "We're going to need a lawyer." Harmon said, "I know a name." The Combs brothers were 23 and 19 years old, living on a 40-acre farm in the mountains of western North Carolina, with a dead grandfather and a list of 22 names and, as of this porch conversation in October 1919, the beginning of an intention that would take them through the better part of the next decade. They went inside. Nora was at the stove. She did not ask what they had been talking about. She knew. She had known since the night she placed the list on the table that the season she had been waiting for had arrived, and she had done what she came to do, and now it was in other hands, which was where it needed to be. She said, "Supper's ready." They sat down and ate. Chapter 2. The Shape of an Old Wrong. The lawyer's name was Caldwell Mace, and he practiced in Asheville. And Harmon had found him through a chain of inquiry that had started with a professor of law at the state university, who had written a paper on federal civil remedies and ended with a letter of introduction from that professor describing Mace as the most serious student of institutional accountability in the Western District, which was the kind of description that meant exactly what it said when it came from a man who chose his words carefully. Mace was 52 and had spent his career working cases that most lawyers in the region would not touch. Not because he was reckless. He was methodical in a way that Eli immediately recognized and respected, but because he had a specific professional philosophy that held that the integrity of the legal system depended on the willingness of some lawyers to challenge it from within when it malfunctioned, and that the worst malfunctions were always the ones that had been tidied up and filed away and were not supposed to be revisited. He read Harmon's document in one sitting, in his office on a Tuesday afternoon in November 1919, with the two brothers sitting across the desk from him. He read it without comment, turning the pages slowly, occasionally going back to reread a passage or compare two sections. When he finished, he set the document on the desk and took off his reading glasses and looked at the two of them for a moment. He said, "This is 32 years old." Harmon said, "Yes." Mace said, "The federal statute of limitations on civil claims for wrongful action by federal officers is 6 years. On its face, the clock ran out in 1893. Eli said, "We know." Mace said, "There is an exception in the statute for fraud upon the court, which has no limitations period under federal equity. If you can establish that the proceeding against your grandfather was not merely irregular, but was the product of a knowing conspiracy between private parties and federal officials to use the court as an instrument of unjust execution, the limitations period does not apply." Harmon said, "Can we establish that?" Mace picked up the document again and looked at it. He said, "The letters in the state archive are the key. If they are what you've described, if they demonstrate knowing communication between a private party and a federal officer about the management of the proceeding, you have the foundation. Everything else builds on that foundation." He set the document down again. He said, "I want to be honest with you about what this looks like. The federal district court is not going to welcome a case that asks it to acknowledge that one of its proceedings 30 years ago was fraudulent. The surviving officials will be elderly, and their lawyers will argue that they should not be subjected to civil examination at their age. The government will argue sovereign immunity on behalf of the Marshal's office regardless of the fraud exception. There will be procedural barriers at every stage." He paused. He said, "And I want to build it anyway. Because the letters are real, and the fraud is documentable, and the statute is there for precisely this situation, and a case like this, even if it does not ultimately succeed in court, creates a record. A federal record in the official docket that says, this wrong existed, and these specific men were responsible for it. That record does not go away regardless of the outcome." Eli said, "That's what we want. A record." Mace said, "Then let's begin." The beginning, as it turned out, was considerably more complex than either of them had anticipated, because the beginning required not just the legal architecture that Mace was capable of building, but a factual foundation sufficient to support it. And while Harmon's work over the preceding 8 months had been impressive, it was the work of a 19-year-old self-taught researcher working from public archives. And what Mace needed went deeper. He needed affidavits. He needed living witnesses, or the documented testimony of witnesses now dead. He needed the chain of custody for the archive letters established in a way that would hold up to challenge. He needed each of the 22 names on Nora's list verified, and their roles precisely characterized, because a civil suit required specificity. It could not allege generally that 22 men were responsible for a wrong, It needed to specify what each man had done and what authority he held when he did it. This was the work of the next 2 years. Eli and Harmon divided it along the lines of their different capacities. Eli took the field work, the traveling, the interviews, the direct contact with the living men and the families of the dead ones. Harmon took the archive work, the reading and cross-referencing and building of the documentary structure that would become the evidentiary backbone of whatever Mace eventually filed. The field work was slow and sometimes dispiriting and occasionally surprising. Eli spent 3 months in the fall and winter of 1919 and 1920 traveling to the addresses on Nora's list, the 9 men she had marked as still living. He did not go to them as an adversary or an accuser. He went as a researcher, or at least as a man presenting himself as a researcher, which was close enough to what he was that it did not feel dishonest. He told them, when they agreed to speak with him, that he was working to document the federal Marshals proceedings in western North Carolina in the 1880s, that he was interested specifically in the 1887 Pratt killing case, and that he understood they had been involved in some official capacity. Most of them agreed to speak because they were old, and old men often want to speak, particularly about things they have not spoken about for 30 years, which can become a kind of pressure over decades, the unspoken thing accumulating weight until the presence of a listener is almost a relief. The first was a man named Earl Beecham, who had been a junior deputy marshal in 1887 and was now 78, living in a frame house in a small town in the valley with a garden and a cat, and the particular reduced circumference of a very old man's life. He received Eli on his porch on a September afternoon, with the wariness of someone who has been waiting for a thing without knowing what shape it would take. And when Eli stated his purpose, the wariness became something more complex. Beecham talked for 2 hours. He said he had been 24 in 1887 and had been assigned to the arrest detail because he was new, and new deputies got the assignments that senior deputies declined. He said he had not questioned the warrant because you didn't question warrants when you were 24 and new. He said he had known even then that something was wrong with it, had felt it, the specific feeling of a thing not adding up, but had not had the language or the standing or the courage to say so. He said, "I've thought about that man a great deal over 30 years. I've thought about his face when we put the rope on him. He didn't argue or beg. He just looked at us with a very steady look, and I have never been able to forget that look." He paused for a long time. He said, "I don't know what you're going to do with what I've told you. I'm old, and I'm not going to fight anything. If you want to put my name in a document that says what happened, I will sign it. I signed the wrong document in 1887, and maybe it's time to sign the right one." Eli thanked him and went to the next name on the list. Not all of them were Beecham. 3 of the 9 refused to speak at all, and one of those had a son who came to the door in his father's place and told Eli to leave and not come back, and Eli left and did not go back. 2 spoke in the hedged, carefully deniable way of men who want to say something and cannot make themselves say it directly, and what they said in that hedged way was noted and added to the file for what it was worth. One was in a state of mental decline that made his account unreliable. One had moved to Ohio, and Eli tracked him there over the winter and found him living in a boarding house in Cleveland, working in a metal shop at 63. And that man, his name was Samuel Prewitt, and he had been a deputy marshal assigned to the courthouse security during the trial, sat across from Eli in a diner on a gray November day and said, in the flat tone of a man who has rehearsed a thing many times, that he had been present when Marshal Corvin received a payment from a man he later identified as the brother-in-law of the Keller family's business partner 2 days before the trial opened. Eli said, "You saw this?" Prewitt said, "I was in the hall. The door was open. I don't know how much I was supposed to see. Maybe I was supposed to see it. Maybe that was the point. that the men around Corvin were meant to understand that the arrangement was real and solid and that they were part of it whether they'd been consulted or not. That's how these things work sometimes. You make a man a witness so he's invested. Eli wrote this down. He said, "Would you be willing to give a sworn statement?" Prewitt looked at his coffee cup for a long time. He was a thin man with large hands and the look of someone who has spent decades at physical labor while carrying something that labor cannot reach. He said, "Yes." He said, "I've been carrying this for 30 years. A sworn statement would be lighter than carrying it." Eli arranged for the statement to be taken by a notary in Cleveland and sent it to Mace. When it arrived, Mace wrote back a brief letter saying it was the most significant single document in the file and that the case was now a case in the real sense. Harmon, meanwhile, had gone deeper into the archive. He had gone back to the misfiled letters and had, with the help of the professor at the State University, established a chain of custody for them that would withstand challenge. He had also found, in a collection of federal court administrative records from the Western District, a series of entries in the Marshals' office expense ledger from 1887 that did not correspond to any documented case activity, but which were entered in the week before the Combs trial opened. The amounts were not large. The ledger was not where a man would record a significant payment, which would require a different kind of concealment. But they were there, and they were irregular, and irregularity in a public record was itself a document when you knew what you were looking at. He had also found, in the newspaper archives, a series of items from the summer and fall of 1887 that collectively formed a picture of the public presentation of the case against Dillard Combs, how the crime had been described, how the evidence had been characterized, how the community had been prepared to receive a verdict that may have seemed predetermined to anyone looking at it closely. The press coverage was not evidence of conspiracy in the legal sense, but it was documentation of the environment in which the conspiracy operated, and environments mattered to Mace's argument that the proceeding had been a fraud from inception. By the end of 1921, they had what Mace called a sufficient foundation. He spent the first months of 1922 drafting the complaint, which was 64 pages long and named 7 defendants, the surviving men out of the original 22, who could be most specifically connected to the fraud through the documentary and testimonial evidence. The others were named in the body of the complaint as involved parties whose roles were documented, but who were either dead or whose specific culpability was less precisely established. 7 names, the 7 living men who had done specific documented things. Mace sent the draft to Eli and Harmon, and they read it separately and then sat at the kitchen table at the home place and read sections of it aloud to their grandmother. Nora sat and listened with her hands folded in her lap, the same position she had held when she placed the list on the table 4 years ago. When Harmon finished reading, she was quiet for a while. She said, "It's accurate." Eli said, "Is there anything it doesn't include that should be there?" She said, "No. You've found things I never knew. The ledger entries. The man Prewitt's account. I didn't know those things." She paused. "Dillard would not have expected you to find those things." "Neither did I." Harmon said, "We had time and we had your list. Your list was the beginning of all of it." She nodded. She did not say more. There was nothing more to say. Mace filed the complaint in Federal District Court in Asheville in March 1922. Chapter 3. The Court of Record. The federal judge assigned to the case was a man named Horatio Stearns, 61 years old, appointed by the previous administration, with a reputation that divided the legal community in the district roughly into those who found him rigorous and those who found him obstructive, which was often the same thing when the case in question asked the court to look at itself. He was not a bad man. He was a man constituted by his institution, shaped by 30 years of presiding over a court that was, like all courts, simultaneously an instrument of justice and an institution with interests in its own continuity and reputation. The complaint landed on his docket like a stone in still water. The first hearing was in May. The government's lawyers, the Department of Justice, had sent 2 men from the Washington office, which told Eli and Harmon something about how seriously the department was taking the case, moved immediately to dismiss on sovereign immunity grounds, which Mace had expected, and Stearns declined to dismiss immediately, which Mace had hoped for but not counted on. Stearns said he wanted briefs on the fraud exception and set a schedule that pushed the next hearing to September. Eli sat in the gallery for the first hearing and watched the proceedings with the focused attention he brought to everything that mattered. He had dressed in the best clothes he owned, not out of vanity, but out of the understanding that a man appearing in a federal courthouse for the first time in a proceeding about the honor of his family needed to appear as though he belonged there, which required effort in his case because he did not, technically, belong there. He was a mountain farmer, and the son and grandson of mountain farmers, and the federal courthouse in Asheville was not a room built with men like him in mind. He sat straight, and he watched, and he learned. What he learned over the following months of briefing and hearing and procedural maneuvering was that the law moved at a pace calibrated to something other than human urgency. That the gap between the time scale of a court and the time scale of a life was not accidental but structural, and that surviving it required the exact quality he had been exercising since the night in 1918, when he read his grandmother's list for the first time. Patience as a deliberate and disciplined practice. Not waiting but working. Not resignation but the active choice to keep going through the slowness, because the slowness was the terrain, and the terrain was what it was. Harmon spent the summer of 1922 doing 2 things simultaneously. He continued building the documentary record, finding new details in archives that the brief exchanges of the early hearings had indicated would be useful. A court reporter's notes from the 1887 trial that had surfaced in a private collection and which Mace had obtained through a months-long negotiation with the collector's estate, a set of correspondence between Marshal Corvin and the Keller family's lawyer that had been in Corvin's widow's possession until her death, and which her daughter, contacted by Harmon through a chain of 6 letters, had agreed to make available. And he was doing something else. Something that ran alongside the legal work and was, in a way, its necessary complement. He was finding the families, not the families of the defendants. He had no interest in them, no angle of approach that wasn't adversarial. He was finding the families of the 22 men on Nora's list. The ones who were dead, the ones whose names appeared in the complaint in a supporting capacity, the men who had been part of this and had spent decades with that fact somewhere in the structure of their lives. He was looking for the children and grandchildren and widows, and he was asking them a question that Mace had said was not legally relevant, but which Harmon had decided was relevant in another sense. He was asking, did he ever speak about it? He got answers of many kinds. From some families, silence, the closed door of people who had made a decision not to know, not to ask, not to let the old thing back in. From some, anger, not at what had been done to Dillard Combs but at the implication that their father or grandfather had been part of something wrong. The defensive anger of people whose memories of a person they loved were being complicated in ways they hadn't asked for. From some, unexpected openness, the relief of a family that had been carrying a thing and recognized in Harmon's question an opportunity to put it down. A woman in Bryson City, 72 years old, whose father had been one of the 7 named defendants, met Harmon at her kitchen table and said, without being asked, that her father had talked about the Combs case on his deathbed in 1934, that he had asked for a minister and had made a confession that the minister would not share in full, but which the woman had been able to partially reconstruct from what her father said to her in the days before the minister came. He had said, there was a man named Combs. He had said, we did wrong by him. He had said, God will account for it if the world doesn't. She gave Harmon a letter her father had written and not sent, addressed to no one, found in his desk after his death. It was 3 paragraphs long, and it described in the plain language of a man writing for his own conscience rather than for any audience, his understanding of what had occurred in the summer of 1887 and his role in it. She said, "I don't know if this helps you or hurts you. I've had it for 18 years and I've never known what to do with it." Harmon said it helped. He was telling the truth. Not because the letter was legally significant, Mace would assess that, but because it was another form of the record, the living record, the accumulation of acknowledgements and confessions and half-spoken things that together constituted the world's ongoing refusal to let the wrong simply be what the wrong had decided to call itself: a lawful execution. He sent the letter to Mace with a note. Mace's note back said, "This is not admissible in the current proceeding, but it is significant for the historical record, and I am preserving it in the case file, where it will remain accessible." The historical record. Harmon had been thinking about that phrase since before the case was filed. The legal proceeding was one kind of record. The official kind. The kind that lived in the federal docket with a case number and a set of findings that would be cited or not cited by subsequent courts. But there was another kind of record, the human kind, the kind assembled from letters and testimony and the things people said on their deathbeds and the things they wrote and didn't send and the things they told their children and the things their children didn't tell their grandchildren and then told anyway when a young man arrived at their kitchen table and asked the right question. That record did not require a judge. It did not require a finding or a holding or a disposition. It existed in the accumulated fact of its own witness, the way a mountain exists, not because anyone decided it should, but because the forces that made it were real and left real evidence, and the evidence was still there. He was building both records. That was the work. In September 1922, Judge Stearns issued a ruling that was the most important single event of the legal proceeding. He declined to dismiss the case on sovereign immunity grounds, ruling that the fraud exception applied and that the complaint had sufficiently alleged the elements of a conspiracy involving federal officers acting outside their lawful authority. The government's lawyers filed an immediate interlocutory appeal, which Mace had expected, and the case went to the circuit court on appeal, which meant another 6 months at minimum before anything further could happen in the district court. Eli was in his office when Mace called with the ruling. He drove to Asheville and sat across from Mace and read the ruling twice. Mace said, "This is significant. Stearns could have dismissed and the circuit would almost certainly have affirmed, and that would have been the end of it. He chose not to." Eli said, "Why?" Mace said, "I think because the fraud exception is clearly applicable, and Stearns is a judge who reads the law as it is written rather than as it is convenient. He will not do us any favors that are not in the law, but he will follow the law where it goes." Eli said, "What does the circuit do with the appeal?" Mace said, "They could affirm the sovereign immunity claim and close the case. They could affirm Stearns's ruling, which sends it back for discovery and trial. Or they can certify a question to the Supreme Court, which is the outcome I consider most likely given the novelty of the fraud exception argument at this scale." Eli sat with this. Mace said, "I want to tell you something that I've been holding for a while because I wanted the case to be further along before I said it." Eli looked at him. Mace said, "What you and your brother have built, the documentary record, the witness statements, the archive materials, is the most thorough reconstruction of a historical wrong by private individuals that I have seen in 30 years of practice. The legal outcome is uncertain, as it always is, but the record you have made exists regardless of the legal outcome. It will be in the federal docket, it will be in the case file, it will be accessible to historians, journalists, future lawyers. It cannot be unfiled. The 22 names are on federal record now, with the specific acts attributed to them. Dillard Combs's innocence, documented by evidence that was never presented at his trial, is part of the official record of this district." He paused. He said, "I don't think you started this for the money or for the formal legal vindication, though I hope we get both. I think you started this to make the record accurate. And the record is accurate now. Whatever else happens, that part is done." Eli was quiet for a while. He said, "Our grandmother gave us a list. 30 years of knowing, and she made us a list." Mace said, "She built the foundation." Eli said, "Yes." He drove back to Burnt Ridge in the late afternoon, the mountains around him in their early fall. The sourwood and the maple already turning at the higher elevations, the light going amber and long across the ridges. He stopped at the home place and went inside, and found Harmon at the table with papers spread around him, which was how Harmon always was, and he told him about the ruling. Harmon listened and then said nothing for a while. Then he said, "I want to go to the grave." They went up the east slope in the last light of the day, through the pasture and into the timber, and up to where the white oak stood over the simple stone, and they stood there in the near dark with the wind coming off the ridge above them. Harmon said, "He's been in here 35 years. Eli said, 35 years. Harmon said, "Grandmother waited 31 years before she gave us the list, and we've been at it 4 years. And we've made it this far." He paused. He said, "Do you think he knows?" Eli said, "I don't know what the dead know." Harmon said, "I think about it sometimes, whether the thing we're doing has any meaning to him, wherever he is." Eli said, "It has meaning to us, and it has meaning to the record. That's 2 things. Maybe that's enough." They stood for a while longer. Then Harmon said quietly, "We're going to see this through to the end, whatever the end is." Eli said, "Yes." They went back down the slope in the dark, the way back as familiar to both of them as anything in the world. Chapter 4. The Weight of Names on Record. The Circuit Court issued its ruling in April 1923. It affirmed Judge Stern's denial of sovereign immunity and remanded the case to the district court for discovery and, if warranted, trial. The government's lawyers filed a petition to the Supreme Court, which declined to hear the case, and in June 1923, the matter was back before Stearns with the legal architecture cleared. The case would proceed. Nora Combs died in October of that year, at 81, in the same house where she had told Eli the list and everything it held. She had been declining since spring, and she died the way she had lived, with deliberateness and without drama. And at the end she was clear-minded, and she asked for her grandsons, and they sat with her, one on each side, and she said what she needed to say, and then she did not say more. She said, "I am glad it is in the record. I am glad before I go that what was done to him is in the record." She said, "He would have been proud of you both, not for fighting. He was not a man who thought fighting was a virtue in itself, for being accurate. He valued accuracy above almost everything. He believed a man who sees clearly and describes accurately is doing something important in the world. That's what you've done." She rested for a while. She said, "Take care of each other." She died the following morning with the early light coming through the window and the mountains outside going from dark to grey to the first pale gold of the October dawn. They buried her beside Dillard on the east slope of Burnt Ridge, under the white oak that had been old when the first Combs settled the hollow. Eli stood at the grave after the few people who had come had gone, and he stood there for a long time. He thought about 31 years of a woman keeping a list. 31 years of knowing and waiting for the right hands. The specificity of that patience, not passive, not resigned, but the active patience of a woman who understood that she was holding something for someone who had not yet been born into the fullness of their capacity to act on it, and who had maintained that holding with care for 3 decades until the capacity arrived. He thought that he would spend the rest of his life trying to be worthy of that kind of patience. The discovery phase of the case ran through 1923 and into 1924. Mace deposed 5 of the 7 named defendants, who were by now between 63 and 86 years old. Their depositions were conducted in offices and boarding houses and, in one case, a hospital room, with the men in the various states of age and infirmity that 36 years of living produced. None of them denied being present at the events in question. That much was in the public record. Their testimony differed in what they claimed to have known and when. The oldest, a man named Corvin, the son of the original Marshal Corvin, who had died in 1909, had not himself been one of the 22, but had been named in the complaint as the inheritor of his father's documented role in the conspiracy. He was 86 and testified from a wheelchair with a clarity that suggested his mind had outlasted his body by some years. He said, with the bluntness of a man who is too old and too tired to maintain a performance, "My father told me what he had done. He told me in 1902. He said they had taken money from the Keller people and hung a man who had nothing to do with what he was hung for. He said it was the worst thing he had done in his life, and he had done some bad things. He asked me not to talk about it, and I didn't talk about it. He was asked whether he had any documentary evidence of his father's account. He said, 'My father's journal, it's in a box at my house. I kept it because it was his, and I am his son. I will give it to you.' The journal was produced in discovery. It was 40 pages long and covered the years 1885 through 1892 and contained, in entries written in the cramped practical hand of a working lawman, the most direct documentation of the conspiracy that the case file had yet produced. Mace read it and sent the brothers a letter with 3 words underlined: "This is definitive." The trial, a bench trial before Stearns, both sides having waived a jury for different reasons, was held in September 1924. It lasted 4 days. Mace presented the documentary case, the archive letters, the ledger entries, Prewitt's sworn statement, the deposition testimony, the journal of Marshal Corvin. He presented the evidence of Dillard Combs' whereabouts on the day of Pratt's killing, Nora's long-preserved account, the corroboration of 2 neighbors who had been children in 1887 and were now in their 40s and testified to their memory of Dillard being on his property that day, and a letter from Dillard's brother, dated the week of the killing, that mentioned a visit to the Combs farm and was consistent with Nora's account in every particular. The government's lawyers argued procedural points, most of which Stearns had already addressed in prior rulings. They argued that the passage of time made the evidence unreliable, and Mace responded that the passage of time had not prevented the government from acting on the original proceeding, which had itself been based on evidence manufactured rather than collected. They argued that even if the proceeding had been irregular, the remedy being sought, a declaratory finding of wrongful execution and a nominal civil judgment, was disproportionate to any cognizable harm after 37 years. Mace argued that the harm was the accurate characterization of what had happened to a man in a federal proceeding, and that the court's role in ensuring that federal records were accurate was not subject to a time limitation when the inaccuracy had been introduced by fraud. Stearns listened to 4 days of this with the attentive stillness of a man who has been listening to lawyers for 30 years and has learned to hear through the argument to the thing being argued about. He asked precise questions when he had precise questions and was silent when he didn't. On the 4th afternoon, Mace rested the case. Eli and Harmon sat in the gallery. They had sat in the gallery for all 4 days, arriving first and leaving last, and they had been recognized by some of the court personnel as the brothers, the grandsons, the men who had started this, and there had been, over the 4 days, a quality of attention in the courtroom that was specific to the nature of the case. Something old and unresolved being brought into a present tense room and asked to account for itself, and that quality had been perceptible in the faces of the people who came to observe. Mountain people had come, people from Harwick County and the surrounding counties who had driven or ridden to Asheville for the trial, not in large numbers but steadily, each day a few different faces. Some of them older people who had their own connection to 1887 or to the Combs family, some of them younger people who had heard about the case and wanted to witness it. They sat in the gallery quietly, and they listened with the concentrated attention of people for whom this story was not abstract, for whom the name Dillard Combs was not a legal abstraction but a man, a specific man who had lived in these mountains and raised a family in them and been taken out of them by something that called itself law. Stearns issued his ruling 30 days later. The ruling was 42 pages long. It found, based on the evidence presented, that the prosecution of Dillard Combs in 1887 had been the product of a conspiracy between private parties and federal officers, that this conspiracy had corrupted the proceeding from arrest through execution, and that the execution had been a wrongful act for which the federal government bore institutional responsibility. It granted a declaratory judgment. The official record of the proceeding against Dillard Combs would be amended to reflect the court's finding that the conviction had been procured by fraud and that the execution had been wrongful. It awarded nominal damages of $1, which was all the statute permitted in a case of this age. It ordered that the amended record be entered in the permanent files of the Federal District Court for the Western District of North Carolina, where it would remain accessible to the public in perpetuity. Mace sent a copy of the ruling to the brothers with a note that said simply, "It is done." Eli was at the home place when the copy arrived. He read it at the kitchen table. He read all 42 pages, slowly, not skimming the legal language but following it, because the legal language was the language of the record, and he wanted to understand the record as precisely as it had been written. When he finished, he sat for a while. He thought about 14 names that were now 7, that were now documented in a federal record with their specific roles in a specific wrong. He thought about the 15 who had died before the case was filed and whose names appeared in the body of the ruling as deceased parties whose roles were documented even in their absence. He thought about 22, which was the number Nora had kept for 31 years, and about the way that number had been carried from her hands to his and then into the federal docket where it was now part of the permanent record of the court. He thought about Priwitt in the Cleveland diner, saying a sworn statement would be lighter than carrying it. He thought about the woman in Bryson City whose father had asked for a minister and said there was a man named Combs. He did wrong by him. He thought about old Corvin in his wheelchair, 86 years old, with the bluntness of a man too old to maintain a performance, saying my father told me what he had done. He said they had taken money from the Keller people and hung a man. He thought about all the people in the gallery over those 4 days, the mountain people who had driven to Asheville to sit and listen, the weight of their presence in that courtroom, the specific gravity of witness, the thing that witness does that nothing else can do, which is to assert by the simple act of attending that what is happening matters, that the world will not look away. He got up and went outside. He walked up through the back pasture to the ridge. The October light was long and amber across the mountains, the hardwoods at peak color, the maples brilliant against the still green pine, the whole range going ridge after ridge in the warm afternoon light. He stood at the top and looked out. He thought about Nora. He thought about 31 years of carrying the list. He thought about January evening in 1918, the fire banked low and the wind at the window frames, and her hands folded on the table and the piece of paper placed between them. He said, aloud, to the empty air and the mountains and whatever in the universe might receive it, "We made the record accurate, grandmother." The wind moved through the timber above him. He stood there for a while in the October light. Then Harmon came up the path from the pasture and stood beside him, and they stood together looking out over the range for a while without speaking, the way brothers who have done something long and hard together stand after it is done, not in triumph but in the specific quiet that follows the completion of a necessary thing. Harmon said eventually, "What do we do now?" Eli considered. He said, "We work the farm. We take care of what needs taking care of. Harmon said, and the case file. Eli said, Mace will keep the case file, and the state archive has everything we collected, and the federal docket has the ruling. It's in multiple places now. It can't be lost from all of them at the same time. Harmon nodded. He said, I've been thinking about writing it. The full account, not the legal document, the human one. What we found, and how we found it, and who we talked to. Pre-Witt in Cleveland, the woman in Bryson City, Beecham on his porch. Eli said, yes, you should write it. Harmon said, I could use your help. Eli said, you'll have it. They stood for another while. Below them, the hollow was going dark, the creek invisible now in the shadows, the home place alight in the trees. The ridge above them was still in full light, the way ridges hold the afternoon longer than the valleys, catching the last of the sun while the world below has already gone to shadow. Eli thought about a man he had never met. 43 years old in August 1887, standing straight on a platform at the federal courthouse in Asheville with a rope around his neck and looking at the men who had arranged this with the steady look that Beecham had never been able to forget. Not arguing, not begging, looking. He thought that the look meant something, had been intended to mean something. Had been the last deliberate act of a man who understood that he could not change what was happening, but could determine how he received it, and who had chosen to receive it with full witness. Looking at the faces of the men responsible, seeing them clearly, making them know they had been seen. He had looked at them, and across 37 years, through the chain of his wife's careful keeping and his grandson's careful work, the looking had come back. The faces had been found and named and placed in the record. The record was now accurate. Dillard Combs, 43 years old, husband of Nora, father of Leland and Chester, farmer on Burnt Ridge in the mountains of western North Carolina, hanged on a Tuesday morning in August 1887 by a federal apparatus that had been purchased to do it. Wrongfully executed, the record now said. The record now said it. The white oak on the east slope of Burnt Ridge continued to grow, as white oaks do, adding a ring each year, incorporating slowly into its own wood the seasons and the weathers and the years, the roots deepening in the mountain soil, the canopy spreading above the two graves, the bark going gray and rough with age. It had been old when the first combs settled the hollow. It would be old when the last combs were gone. It did not know what it stood over, did not know the names of the people in the ground at its roots, did not have any accounting of wrong or right or the long human work of making them align. But it stood, and the graves were beneath it, and the record, in the federal docket and the state archive, and in the account that Harmon would write and the account that Eli would help him write, was accurate now. That was the work. That was what the brothers had been for. Harmon started down the path first, picking his way through the near dark with the ease of a man who has walked this ground 10,000 times. Eli followed, one hand briefly on the bark of the old white oak at the path's edge as he passed it, the rough surface of the bark under his palm for just a moment, and then he was past it and moving down the slope toward the light below. The mountain held everything it had always held. The light in the home place window was steady in the dark. The Combs brothers went home. End.